qualified immunity.
The qualified immunity defense.
On the problem of qualified immunity.
Qualified immunity.
Qualified immunity.
Qualified immunity.
Because agents of the government are entitled to a special privilege that's not available to any other citizens accused of breaking the law.
Because of qualified immunity.
Qualified immunity.
The legal concept known as qualified immunity.
You know what qualified immunity is, right? You're aware of that, right? Okay, so don't fit up right now.
Pretty familiar.
Okay, good.
What's up, ladies and gentlemen, and welcome back to another video. With today's video, we're going to explore a topic that a lot of people talk about, but most don't understand. And that is qualified immunity. Let's unravel the hellish nightmare that is qualified immunity. A legal atrocity that's not just bad, but downright destructive and counterproductive. Buckle up, because we're about to expose the dark side of our supposed legal system.
When law enforcement officers break the law, they should be held accountable.
To the extent that qualified immunity fosters a sense of, it's really not my problem, let's take a look at it.
Qualified immunity is a legal doctrine that was developed through court precedent rather than through congressional legislation. The purpose of qualified immunity is to protect government employees from frivolous litigation. However, it's become an increasingly effective shield in thousands of lawsuits that are seeking to hold cops accountable when they're accused of excessive force.
Now, the law is written says that the family can do that. It says that the victim of civil rights abuses can do that. Congress passed an act that dates back to Reconstruction. It was called the Ku Klux Klan Act. And it says very clearly that victims of state violence, civil rights abuses, have the right to hold government officials accountable. The Civil Rights Act that Congress passed in 1871 created the legal violation, really, the right to sue. Qualified immunity is something that courts invented, and it says, think again. It says we don't care about any of that. We are going to make him immune.
In 1871, Congress passed the Civil Rights Act and established the right for ordinary people to hold local and state officials accountable in court for constitutional rights violations. This law was passed in direct response to the terror inflicted on Black Americans by state officials after our nation's Civil War. Today, the Supreme Court has all but eliminated this right, and the resulting police violence that falls most heavily on Black and Brown communities is in direct contradiction to the intent of the Civil Rights Act. Over the past several decades, the court has defined qualified immunity in a way that has made it virtually impossible to hold officials like police officers accountable unless their victims can point to a specific court case that outlines a clearly established statutory or constitutional right. But what exactly does that mean?
In a case called Harlow versus Fitzgerald, they announced the modern qualified immunity test, which says you can only sue a police officer if they violate clearly established law. Then in the sort of 40 years since then, there have been a drip of maybe 30 or 40 cases where the court makes the test a little bit harder every time and makes it really hard to find anything to be clearly established law.
So when granting qualified immunity, judges are looking at a kind of a two-part test. First, was there a civil rights violation? And secondly, was it clearly established? But a more recent Supreme Court decision in 2009 allowed judges to skip the first part of the test and only answer, was this violation clearly established as a violation? If a certain excessive force conduct is brought before the court and dismissed from qualified immunity because it wasn't established, that also prevents it from being established for future cases.
The degree of specificity that the court has required of victims and their families to get any sort of relief or accountability in the courts is quite extraordinary. For anyone else, if you're talking about a doctor You're talking about a construction worker who you want to hold accountable, showing that they violated the law. You can come into court, we'll hear you, we'll give you a trial. But when it comes to police officers, when it comes to state officials, don't even try that. You better be able to show us a case where we said this specific conduct was wrong. The degree of specificity that the court has required of victims and their families to get any sort of relief or accountability in the courts is quite extraordinary. There's a case that went up to the Supreme Court recently that the Supreme Court declined to hear, and it involved sicking an attack dog on an individual. And in that case, there actually was a prior case. A man had already surrendered, and an officer nonetheless sicked the attack dog on that man, and the court said that is a constitutional violation. And what the lawyers for the police argued in this case was, well, but in that case, the man was laying face down when he had surrendered. And in this new case, he was sitting with his arms up. And that distinction is sufficiently relevant to say that this officer should get immunity.
Our team of reporters read through hundreds and hundreds of lawsuits, and we found that not only is qualified immunity a very common outcome, but that it's been getting easier and easier for police to have lawsuits thrown out because of qualified immunity. And we're seeing that this is especially true in cases where the judge rules that the rights were violated, but they're still granting qualified immunity. From 2005 to 2007, we were looking at cases where defense raises a qualified immunity defense. And in those cases, there was a qualified immunity ruling that favored the police in only 44% of cases. But in the more recent years, from 2017 to 2019, the ruling on qualified immunity favored police 57%, more than half the time. And there have been a number of Supreme Court rulings in that period in between that made it much more difficult for plaintiffs to overcome qualified immunity. It's a pretty growingly controversial doctrine, even within the Supreme Court itself. For example, Sotomayor in particular has been outspoken in some of her dissents, writing, for example, in one, it's telling police that they can, quote, shoot first and think later, and it tells the public that palpably unreasonable conduct will go unpunished.
Qualified immunity requires is not that law enforcement officers follow those general principles, but that the plaintiff be able to find a prior court decision with virtually identical facts. As just one quick example, it is well known and established that a police officer cannot use force against a person who has surrendered and is not posing any harm. But a man named Alexander Baxter had his case thrown out of court on qualified immunity grounds when he had surrendered to police with his hands in the air, and the officers nevertheless released a police dog on him, even though in that same court they had said releasing a police dog on a person who was lying down in surrender was excessive. To the court's mind, Alexander Baxter's case was not similar enough because he was sitting up instead of lying down when the police dogs were released upon him. This is not a matter of notice. It's a matter of common sense. And officers should be able to understand that it is not appropriate to release a dog or use force against a person who has surrendered without being able to identify a precise case with virtually identical facts.
So at its inception, qualified immunity's intent was good. It was meant to protect officers who made honest mistakes from frivolous lawsuits. But the birth of qualified immunity alone is an abomination to the law. The judicial branch does not get to create laws. But here, the judicial branch, the Supreme Court, created qualified immunity out of thin air without the legislative body's help. In the years since its abominable creation, qualified immunity has become perverse and warped. Qualified immunity has now become so perverse in its application that it is being used to shield bad officers from the bad things that they do, from civil rights violations to outright criminal acts. Families seeking justice from a police department or a police officer that had done wrong to them are often denied this justice because of qualified immunity.
On July 10, 2014, police officers in Coffee County, Georgia, entered a private yard where 6 children were playing. The officers, who were in pursuit of a criminal suspect, ordered the kids to get face down on the ground. When the family dog came out into the yard, one of the officers fired at the dog twice, but missed. One of those bullets struck a 10-year-old in the back of his knee. When the child's mother attempted to sue the officer for damages, the case was dismissed due to qualified immunity.
I'm following you, Andy. Go.
The Henry County SWAT team locked and loaded.
Wait for the bang. Grenade.
They've got a no-knock warrant for an accused drug dealer.
Show me your hands! Show me your hands! I got this one.
8 body cameras were rolling in 2018 as the heavily armed deputies searched for their target in McDonough.
Sheriff's officer!
Something went off like a bomb in my house. I thought something was loaded up in the house.
Sheriff's officer! I need a kick. Kick! Sheriff's office!
Got to the hallway, they was all over me.
Show your hands! Get on the ground! Get on the ground now!
I said, what's going on? He says, no, you get down.
Show your hands! Get on the ground! Get on the ground now! Get on the ground!
Grabbed my arm, twisted behind my back, and handcuffed me.
Put your hands out in front of you, sir. Put your hands out in front of you.
Anybody advise if we have the target?
79-year-old Henri Norris was not the target. Deputies had the wrong man and the wrong house.
Sheriff's office, search warrant!
I can't even imagine what he went through. I mean, like the Breonna Taylor situation. She's dead and gone. There's nothing that can be done to bring her back. And how many Breonna Taylors have to die? How many of my grandfather's houses have to be broke into? I mean, and that's how I feel like you're broke into his house because you had no authority. You had no reason to be there before we get change. I mean, a change has to happen and needs to happen because more people are gonna die.
Geronimo!
If you're not safe in your own home from the government, when you've done nothing wrong, where are you safe?
Clearly nowhere. It's really sad and it hurts even more because my grandfather has never been in any trouble with the police. He's never even had a ticket.
Henri was watching television in the McDonough home he's owned for 50 years. The no-knock search warrant was for the house next door through the woods. So how did deputies end up hitting a house with a different color, a separate driveway, its own mailbox, and another address?
Missed it.
We just got up.
Missed it.
First, the tactical team got lost following instructions from a GPS app on a phone.
Turn right on me.
Then, as soon as they got to the correct address, deputies were immediately confused.
Where's the house? Where's the house? I don't know about that house right there. Where we at?
They walked right past the target house without clearing it and headed through the tree line to the next house on the street. Even then, deputies were unsure.
This house? This house?
Looking back and forth at the two houses, it was too late. The entry team was already forcing its way into Henri's home.
Kick!
That scared me to death. I'd already had heart trouble. I had heart surgery.
You got heart trouble. You got what? Heart trouble. All right, you have heart problems right now?
Yeah, I could have died. I could have had a heart attack.
When they finally realized they'd hit the wrong house, deputies turned their cameras off one by one.
Yeah, a pizza delivery man could deliver a pizza to the correct address.
Daryl Scott is Henri's attorney. He sued Henry County's tactical commander, but a federal judge dismissed the case because police officers are entitled to qualified immunity.
That's what happens in the majority of cases. The cases are dismissed and officers are granted qualified immunity even when there's a constitutional violation.
Search warrant!
What is qualified immunity?
Qualified immunity is a court-invented doctrine that allows law enforcement officers and other government actors to avoid accountability when they violate a citizen's constitutional rights.
Judges created qualified immunity to protect individual officers from liability, unless victims can show the officers violated rights that are clearly established.
Shouldn't every officer know you don't knock down a door at the wrong house? Shouldn't every officer know you don't go handcuffing people who aren't the targets of your investigation? Shouldn't every officer know you don't throw a flashbang grenade into the wrong house?
Yeah, I think that's clearly established. That should be obvious for any law enforcement officer. That's obvious for untrained citizens.
The officers used a battering ram to enter the wrong house, used flashbang grenades, handcuffed the wrong man in the wrong house, and their get-out-of-jail-free card is I'm sorry and qualified immunity. Does I'm sorry cut it?
No, sorry, it does not cut it. It just shows that that badge is a get-out-of-jail-free card. It's showing that if I have a badge, I can say I'm sorry, and I have no accountability.
The government has given officers a blank check to go out in the community and break the law. They feel like they have the right to do that with no consequence.
As a screening mechanism for frivolous lawsuits, and what it's morphed into is almost absolute immunity for law enforcement officers.
If they're able to get away with this and not be held accountable, what's the danger then?
But they're going to just keep on doing it. They probably go into somebody's wrong house, somebody's going to get hurt.
Henri hasn't seen a penny in restitution, but his attorney, Daryl Scott, has filed an appeal with the 11th Circuit U.S. Court of Appeals, where he's already won a reversal in a similar case of qualified immunity.
Turn around.
No.
I got a man up here taking pictures.
Sir.
I don't want him taking pictures of our yard.
Sir.
He don't have authorization.
Sir, this is
He
public
not
property.
proved who
Please
he
step
is.
aside.
Not shooting that way. Turn around.
No.
Turn around.
The car was on his property, but we were on a public sidewalk.
Stop taking pictures to the police.
Sir, I do not have to take your unlawful orders.
What's so special about this particular Toyota? It was impounded by Clayton County Police from owners Michael and Michelle Pierce. The couple runs a thrift shop, and they routinely buy the contents of unpaid storage units. Their $1,700 bid won an auction for the Toyota.
And then we found out it was stolen.
They immediately called 911 and turned the Toyota over to police. But when Michael and Michelle discovered no one had a claim on the car, they went back to the Clayton County Police Department and got this signed release from Impound.
Part of the procedure was to run the history of the vehicle, and it was clean and clear. Of course, that's why we got the T-22, the title bond, and Clayton County released it to us.
Then they got a call from Clayton County Detective Randy Brashears. He put the car back on the stolen list and demanded they hand it over again.
They called and said they made a mistake by releasing it to me, and that they was going to lock me up if I did not give it back.
An army of cops showed up at the couple's store.
We even got a tag and title bonded and everything.
And took the car away on a rollback. That was July of 2015 when they called the 11 Alive investigators. We sent an email to Detective Brashears. It's not clear what crime Michelle Pierce would have violated or why the threat of arrest was necessary for what would appear to be your department's mistake.
What did I do?
Just days later, Detective Brashears went back to the Pierce's shop with more officers.
They came in here and snatched me up as if I'd shot and killed somebody, and then turned around and locked my wife up, and never one time told us why they were doing it. They just did it.
Okay, so why am I under arrest? I haven't done anything.
That had to be the worst moment of our life.
It was just a nightmare from there on. I'm sitting there pleading with the detective, and I'm telling him, I'll get Brendan not to air the interview where we're asking for the money back.
They were both jailed for auto theft, and Michelle was also charged with felony forgery.
Trying to tell people, hey, I'm in here and I didn't do nothing wrong, you feel stupid, so you just shut your mouth and sit there. When we went to see the judge, they shackled us like we were criminals.
When they made bail, another Clayton County police officer met the couple in a Walmart parking lot.
You got blue collar crime, and you got straight up like murder, rape. We can't help you with them kind of charges. Exactly. This, they can go away.
He said that he had people
On the inside.
who would get rid of these charges.
Yes, and he said he's done it before.
The couple secretly recorded their meeting with Officer Grant Kidd.
He used to charge $750 each and each one of them. $750. And you pay $1,000 up front, then the rest of you pay after it go away.
This police officer was telling you if you paid him $1,500, the charges would disappear.
Yes.
If it don't go away, if it go into the grand jury and you get your money back.
Clayton County immediately fired Officer Kidd, and then the FBI arrested him for soliciting a bribe from the Pierces. The DA then dismissed the case against Michael and Michelle, saying the car was legally purchased at auction, and there is no evidence beyond a reasonable doubt that the defendant sought to defraud anyone.
At the end of all of this, the district attorney determined no crime had been committed.
Well, I mean, a 2-year-old could see that.
Detective Brashears is still on the job.
I want him held accountable. I don't care if he gets a slap on the wrist, but he done wrong, and if he done it to us and he's not held accountable, he can do it again.
He didn't respond to our request for an interview, so we caught up with him at police headquarters.
Can we help you?
Yeah, I'm Brendan Key from 11 Alive. Detective, can you tell us why you arrested the Pierces when even the DA says you didn't have a case?
Sir, you've been told by our attorney that we have no statement for you.
We went to jail. We were punished for doing the right thing.
You have nothing to say to the Pierces after denying them their freedom?
I know that God and karma will get him.
Did you arrest them because they called us? Was it revenge?
Yeah, this is too easy. We got a stolen car, man. This is too easy. Let's turn it in and try to steal it back from the police.
Do car thieves, in your experience, usually call the police?
Officer Grant Kidd pleaded guilty to soliciting a bribe and got probation. But the lawsuit against Detective Brashears was thrown out.
My ex was involved in a serious accident. On investigating, I found out that they had been drinking at Fajita Jack's, so I went there to start. When I arrived there, I noticed that a truck matching the guy that she was in an accident with was sitting in the parking lot. Once I left, I noticed that there was a gentleman in the truck, and I figured it might have been the guy who she was involved in an accident with, so I went to go see. I noticed it was an older man and decided that it probably wasn't the right guy. When I went to leave, the guy got out of the truck, ran around to the driver's side of the vehicle and told me he was going to put a bullet in my skull. At that point in time, he tried to smash the window out of the Corvette and open the door. Upon doing so, it jammed the gun. He went around to the front of the vehicle to prevent me from leaving. He tried to pull the trigger. I didn't know he was an officer. He never identified himself. And at that point, the officers came in and I kept asking them why was I being arrested, why was I being detained. They never would tell me. It wasn't until later that they came back and they told me he was a federal agent. It was Homeland Security. Another officer came to the vehicle. He said, "Mr. Bird, what happened?" I told him what happened. He said, "That's not what Agent Lamb is telling us." That's when I told the officer, I said, "Go get the security footage." The officer came back and opened the door and spoke to me. He said that they had seen some security footage and I told the truth. He asked Agent Lamb 3 times to tell him what happened. Agent Lamb kept telling him that I followed him. Since he was a federal agent, they pretty much said that you can't sue him, there can't be any criminal charges against him. They pretty much have a badge and they can do whatever they want. What's to stop him from doing that to somebody else next time the gun doesn't jam?
This is a 911 audio recording of an eyewitness to an arrest.
I don't know if these are undercover officers that are on top of this man, but this man is screaming, "Call the police, call the police."
This phone call was clearly made before the video was shot.
So I don't know what's going on, but they're beating him up. They're literally assaulting him.
The guys on top are, in fact, undercover cops. The shirtless guy is a criminal suspect. Emphasize suspect. This was back in 2014 in Grand Rapids, Michigan. James King just had the stuffing knocked out of him because he bit one of the cops.
I bit the officer on the arm because he put me in a chokehold and I blacked out. And when I came to, that was the only thing I could do to save my life at the time.
And then what happened?
He let go eventually, but then he proceeded to punch me in the head until I couldn't move anymore.
Which brings us to what may be the central argument for a legal doctrine known as qualified immunity. You don't want law enforcement officers taking down a potentially dangerous suspect, worrying about the possibility of a civil lawsuit. James King and the actual suspect didn't really look much alike, but, well, mistakes do happen.
I didn't make it more than 5 steps and I was tackled.
James can tell you all about that. He was working 2 jobs back in 2014 and was on his way from one to the other.
2 gentlemen, scruffy-looking guys, backwards ball caps, came up to me and said, "Hey, who are you?" And I said, "Hey, I'm James. What's up? What's going on?" And the first guy asked, "Is that your real name?" And I said, "Well, yeah, of course that's my real name." And then the other guy stole my wallet out of my pocket.
James confirms that they had badges around their necks, but he thought they were fake. Police say they were checking for his ID when one of them took his wallet.
That was the moment where I thought I was being mugged, and I turned to run, and a fight ensued, and I started to yell for the police.
But as a consequence of your fighting back against what you think is a mugging, you are now accused of assaulting a police officer.
I did for 9 months felt like I was living in a nightmare and unsure of whether or not I was going to go to prison for a crime that I didn't commit.
James King was lucky, even luckier, he says, because he is white.
My criminal trial attorney, one of the first things he said to me after I told him what happened, he looked me in the eyes and he said, "If you were black, they would have killed you." I knew he meant it, and that has always stuck with me.
So, to repeat, James was lucky. A, because he's not dead, and B, after legal proceedings that dragged on for many months, a jury found him not guilty of assaulting a police officer.
When I spoke with my criminal attorney, he told me, this thing happens more than you would hope, and most of the people that try to fight these things don't win. Many people that have had happen to them what happened to me, they're in jail right now or worse.
But what about the arrest that set all of this in motion? Couldn't James sue law enforcement for damages? Well, he could, and he did, and attorneys for the cops invoked qualified immunity.
The substance of constitutional rights is meaningless if state actors can violate those rights with impunity. Such rights would become, in James Madison's words, parchment barriers, symbolic commitments to individual liberties that do nothing in practice to deter or prevent unlawful misconduct by government agents. Unfortunately, most members of law enforcement operate today in a culture of near zero accountability. Police officers rarely face meaningful consequences for their misconduct, and the public's accurate perception of this fact has contributed to what can best be described as a crisis of confidence in our nation's law enforcement. Accountability has therefore become a top priority for anyone interested in criminal justice reform. Coming up, we're going to meet a man from Texas who challenged the police and their qualified immunity. His name is Philip. Philip took a stand, challenging the application of qualified immunity. Through persistence and legal strategy, he managed to prevail. Shedding light on the nuanced aspects of this legal defense, Philip Turner's story serves as a reminder that although challenging, overcoming qualified immunity is not impossible, offering hope for accountability in the face of unjust actions.
Sir, do you have any ID? Yes, no, maybe? Do you have any ID, sir?
Am I being detained?
For investigation. With everything that's going on and on, we have the right and authority to know who's walking around our facilities.
No, that's incorrect.
Okay, do you have your ID? Are you refusing to ID yourself? Yes or no?
What happens if I don't ID myself?
No? Then we'll cross that bridge when we come to it.
Okay. But you have to tell me what happens if I don't ID myself.
No, I don't. Okay. I'm not required to tell you that. Are you, yes or no? Are you refusing to ID yourself or not?
Once again, what crime have I committed?
I've already explained that to you. I don't need to explain it to you again. Are you or are you not going to identify yourself?
Are you familiar with Texas Penal Code 38.02?
Answer my question. I get to answer the questions here. It's my investigation, not yours.
I'm not going to ID myself.
Okay. All right. Let's go. Stand down. There you go. Put your hands behind your back. This is what happens when you refuse to ID yourself. Nope. Just relax. All we're going to do is ID you. Yep, absolutely. Give us just a minute. West 112, go ahead.
Are you by chance in the parking lot with somebody that was videotaping, officer?
Yes, I am. Just having detained at this time.
Any other traffic units have an auto pad 4800 South Hill?
West 112, can you start a supervisor?
I'm handcuffed. Why are you bending my wrist?
National Secretary Supervisor.
Can you? I'm handcuffed. There's nothing
So what is?
to do.
Who are you? What is your name?
Bending my wrist, man. I'm handcuffed. I'm handcuffed, man. You're bending my wrist, dude. Can you let go of my wrist? Can you let go of my wrist? Man, quit bending things.
Is your straight?
Quit bending.
All I'm doing is holding your hands. I'm not bending it. Which way you want to go?
Just let your hands out, man.
Who are you?
None of your business.
Okay. So you're gonna go down and get fingerprinted then. So let's figure out who you are. You're playing this the hard way. Why you got to play it the hard way?
What I got to do, man? What I got to do?
All right. You made the choice, not us. We'll log this in as a seized property. If you want to identify yourself.
I'd love it if you could tell me what paragraph in the complaint reflects that these officers were taking any investigative steps while he's sitting in their car. So just tell me in the complaint, what were the investigative steps they were taking while he's sitting in the car?
All the complaint says is that he was detained for a brief period in the car while a supervisor, who the complaint says was in the building next to them, showed up moments.
What's the investigative purpose that the complaint alleges?
Seeking identity, Your Honor, which Supreme Court case after Supreme Court case after Supreme Court case.
Yeah, but you know, I'm sure you know, Texas law is not like Louisiana law. You cannot ask for an identity card under the Texas law after Texas v. Brown unless you can lawfully arrest them. That's different than...
It's not a crime under Texas law, but absolutely as part of the investigation, you can seek identity. It's not a crime for the...
But what's the crime justifying the detention? Like, in all these traffic stop cases where we agonize about how long they can keep him in the car, they're getting a dog because they have reasonable suspicion of drugs. They're going to do a show-up because they have reasonable suspicion of bank robbery. What in the allegation, only in the allegation, says that they were looking for what crime?
They were seeking his identity, Your Honor, as part of...
But that's not a crime under Texas law. What's the crime?
Nor was he arrested. This is part of the detention, Your Honor, that is justified by reasonable suspicion. And contrary to what was being said numerous times, in the complaint it says that the officers approached, asked him how's it going, and asked him to identify himself. Mr. Turner kept videotaping, and Officer Reynolds repeatedly kept asking Mr. Turner if he had the ID with him. They didn't walk up and detain him before he refused to identify himself.
He doesn't have to identify himself under Texas law, correct?
He doesn't have to in order for it not to be a crime. It's not.
So what's
that's a red herring.
Crime they have suspicion to detain him for?
It is a crime of perhaps terroristic activities, perhaps.
Where in his amended complaint does it suggest he was, did they say to him, we think you're a terrorist?
Yes, they said, we have concerns about what's going on outside of our facilities.
That's not a crime. We have concerns.
Right, and you don't have to, under the Terry standard, identify a specific crime. You just have to have a reasonable suspicion under the totality of the circumstances.
That criminal activity is afoot. You have to have
criminal activity may be afoot.
Right. And what you're saying that they had, the criminal activity they were investigating was terrorism. Do you agree we have to accept his allegations are true for the dismissal?
Yes.
Okay. They said, we're putting you in the car to make you sweat. This is what happens to people who don't give us ID. He said that. You're stuck with that at this stage. How can that possibly, in the last 30 years, justify an arrest or even a detention? To make you sweat.
Again, on even accepting that standard, it is not relevant under qualified immunity law or Fourth Amendment law, the evil intentions or evil motive of the police officer.
30
So even
years
if they
ago, the
said
Supreme
something-
Court said you can't detain for punitive purposes. Sounds like make you sweat is punitive. Has to be for investigative. Our court over and over again has said there's got to be an investigative purpose once you detain. Bank robbery, whatever. And if we accept, it may be provable later on, but he says they were doing it to make him sweat.
So I have two answers to your question, Your Honor. One, under the Fourth Amendment, and I cite a case, U.S. v. Goodwin, out of the Seventh Circuit, which cites a number of Supreme Court cases, Indianapolis versus Edmond, Florida versus J.L., Illinois versus Lidster, where they say, in essence, there's a sliding scale. If the crime that's being concerned, that the officers are concerned about, is significant enough, the level of suspicion can be lower. And in this case, I would love to recount the history that I put forth in my brief, but I know you know it already, of what these officers were fearful of, including the events the very days before this happened.
That may be true, but we can't assume that. That's guessing. We have to take his allegations as true, that the officers come up and say to him, you won't give us ID? Okay, you're going to make you sweat.
No, what his complaint says is that when he refused to give ID repeatedly, the officer says, and he asked the officer, why are you detaining me? Or why are you arresting me? The officer says, we're not arresting you. We're not accusing you of a crime. We're simply detaining you to try to determine your identity. And
that doesn't work for Terry under Texas law. They can't detain him to get his identity unless the only basis under Texas law you can get identity cards is if you have lawful arrest.
I knew that it was a First Amendment right and that something needed to be done. So behold, 2 years later, here we are, and we clearly established this right in the Fifth Circuit, and we did it together. I have been turned down by many organizations that I asked to represent me. I have been turned down by the Texas Civil Rights Project. I have been turned down by at least 10 different attorneys. I even submitted requests to ACLU, and I've heard nothing back. Not even a response saying that they couldn't represent me. Not a single response back. And I submitted a request to them 3 different times for 3 different situations, and they all refused. And finally met a lawyer, Kervin Altaffer, out in Dallas. He decided to take my case, and we covered a lot of ground. And after working with him for just maybe almost a year now, we have already clearly established a First Amendment right to record police officers in Texas, and it's the first of its kind. And I can clearly say that I'm very proud of that. You know, I want to accomplish a great deal of things. However, in order to accomplish a great deal of things, you have to be determined. You have to want it.
Philip Turner's case stands as a reminder that although it might be challenging, qualified immunity is not impossible to overcome. Now let's turn our attention to another activist that has overcome qualified immunity, and his name is Eric Brandt.
You're going back to concept. Oh, it's every day. I thought I would have got like a calendar or something. Oh, it's every day. Anyone have to worry about being a weapon? We need to talk for a minute, okay? Am I a suspect in a crime? Yes, you are. Which crime specifically am I a suspect? Trespassing. Trespassing? We've been asked to leave the property, okay? Right now you are trespassing. So I'm setting this down so that it's not a weapon. Awesome. Let me advise you that this is public property. Actually, this is private property that you're on. Oh, it is? It is. Who owns it? No trespassing. The Adams County government. The Adams County government. Oh, I forgot about his name. Didn't he run for president? No, he's not a person, it's the public! What the fuck is wrong with you people? Sir? No justice, no peace, Fuck the police! You've been asked to leave the property. Yeah. You are now committing trespassing. Okay? That's all we're asking you to do, is to leave the property. I need your card. I will give you my information when we're done. No, you're okay. Now. No. Yeah, you'll identify yourself before you take any official action. That's what you're doing. Right? That's what you're doing. Badge number 2905. Okay? So, Mr. Dickey, why are you removing me from public property? No, it's Mr. Dickey. I'm removing you from private property because you were asked to leave this property. Yes. Posted signs don't. This is a building open to the public. It is open to the public right now. Does your house say private property on it? That's a different aspect. No. Oh yes, it is. Does it have a sign? You really need to learn the Castle Walls doctrine. Does your house say my house doesn't need that? This is public property and it's open to the public right now. You have been asked by these people to leave, by the people in here to leave. Therefore, you are trespassing. Will you be willing to write me a citation? Absolutely. In fact, I will arrest you for it. Well, I prefer not to have a custodial arrest, but I would like a citation. Okay, I will arrest you if you do not walk off this property. You are committing disorderly conduct and trespassing. I am not committing disorderly conduct! Yes, you are. How specifically am I conducting disorderly conduct? You're the one that knows the laws. I'm expected to know. Yes, I do know the law, and I goddamn well know I'm not committing disorderly conduct. Do you know what the terms of disorderly conduct are, sir? Yes! Do you know the essential elements of disorderly conduct? Yes, I do. That's why I'm asking. Do you? Well, this is a public space. I don't see a residence nearby. It doesn't have to be a residence. Let me advise you that A, I'm protected by the First Amendment, and B, I'm represented as the #1 civil rights attorney in the country. So you really don't want to fuck this up today. Okay, I need you to put in writing that I'm being trespassed. I will. I need to have that in evidence. What I'm telling you right now is the goal that you need Are you going to give me something in writing that says I've been trespassed from this public property? No, I don't. I'm going to the property. And the fucking sign stays up, asswipe! What the fuck is wrong with you people?
I'm sure many of you now have heard of Eric Brandt. He has been one of the most prolific and controversial cop watchers in a world where provocative antics and unconventional tactics are part of the norm. But what makes Eric's case so interesting and worthy of more attention is how sometimes an unorthodox approach can lead to unexpected results. First, let's start with some background on Eric and his entanglements with the law, and most importantly, his unique approach to holding cops accountable. Like so many so-called auditors, Eric has been known to confront police officers. The former enlisted Navy sailor has posted a variety of videos with provocative posturing that has led to run-ins like this.
You need to be so aggressive. You need to be so aggressive.
All right, go ahead. But I need you out.
In fact, Eric most notably posted a widely circulated video that has become legendary in the cop watching community with his song, excuse my French, Happy Fuck the Cops Day. Let's listen.
Greetings, happy fuck the Cops Day.
And this approach has caused trouble for Eric, especially his threats made during coverage by the mainstream media after a court hearing resulting from one of his encounters with police. Shortly after a judge ruled against him, Eric was caught shouting threats against a judge that later led to more legal trouble. But the story doesn't end there, nor does the complexity of Eric's approach to asking for accountability. That's because while the mainstream media has been working hard to paint Eric as a menace to society and law and order, he has been quietly racking up court victories that have gone a long way towards holding police accountable. Brandt's story exemplifies all the contradictions of the cop watching movement and the state of policing in the country. On the one hand, you have a man who is viewed by the mainstream media as a classic bad actor, a threat to civic discourse, and a man who takes things too far to prove a point. But on the other hand, Brandt has made real progress. He has won several key cases that one could argue have cleared the way for more meaningful reform of what we can all agree is a troubled criminal justice system. First, he won a court ruling that makes it legal to stand outside a federal courthouse and inform potential jurors about their right, not just to find someone innocent, but to nullify the charges. He was initially accused of jury tampering, but the case made its way all the way to the Colorado Supreme Court, where his actions were found to be constitutional. Second, after being arrested for displaying an offensive tattoo, a tattoo in the shape of a middle finger surrounded by the words, F the cops, he won a case that ordered First Amendment training for Englewood, Colorado police officers and forced the department to equip the cops with body cameras. He even got an annotation to case law governing disorderly conduct charges, expanding the range of constitutionally protected speech during protests. In fact, just recently, Eric was in court facing charges of making threats to a public official, which took an intriguing turn. So before we got to our interview with Eric, I'm joined by my reporting partner, Stephen Janis, to talk about what occurred during these unusual proceedings. Stephen, thank you so much for joining me.
Tay, thanks for having me. I appreciate it.
First, just to set the story and Eric's tactics in proper context, from your experience covering police reform efforts for over 15 years now, how hard is it to actually reform policing?
Well, to put this in context, after the 2015 uprising and the death of Freddie Gray in police custody, State Senator Jill Carter introduced a series of reforms, which she had introduced 5 years prior, and not a single reform passed. So even in the most exigent circumstances, it seems like state legislatures are controlled by the FOP, which would be the police unions, and are hesitant to make any sort of change or reform.
Stephen, you have covered a lot of sentencing hearings in federal court, but what happened in Eric's case was pretty unusual. Can you talk about what you heard?
Well, you know, we were listening to it, monitoring the sentencing, and when we listened to it, we heard the arguments on behalf of Eric. We thought that that was his defense attorney, but in fact, it turned out to be the prosecutor. The prosecutor made a very eloquent case that Eric's work was activism, that he was trying to fight back against unjust power. So really, it was the most bizarre statement by a prosecutor who was supposed to be convincing a judge to sentence Eric to an extended term or long term in prison, but instead was advocating for his release.
Now, the controversy over Eric's inflammatory remarks raised a lot of questions about the whole idea of cop watchers being engaged in police reform. How do you put his behavior into context?
I mean, I think Eric is in a long tradition of American dissent, which is dissent by, to a certain extent, you know, art, a dissent by kind of a way of creatively showing us to take a look at something that we kind of accept for granted, but don't really understand or fathom how deeply unjust it is. People like Eric push us to look at it in a completely different light, in a completely different context, and that's what makes it so interesting, and I think a vital form of American, dissent.
Now, of course, the best way to tackle these issues is to talk to the man himself, Eric Brandt, and here he is joining us today. Eric, thank you so much for being here. So what I would like to discuss with you is some of the changes that were made to case law that caused police reform because of your arrest. And in most of the cases, you represented yourself pro se without a lawyer. So the first arrest I would like to discuss begins with you educating the public on jury nullification. And you told me that lawyers David Lane and McNulty assisted you with this case, right?
We were handing out literature that was published by the Fully Informed Jury Association. That's FIJA, FIJA.org. This is literature that educates people on the rights and powers of jurors. And in particular, it advises people of the power. If it's not a right, it is certainly a power that jurors have to find criminal defendants not guilty, even though the prosecution has fully met their burden according to the elements of the charge. So we were handing out literature that was produced by the Fully Informed Jury Association. I downloaded off of their website. I printed out about 200 copies, and we were handing this literature out in front of the Denver courthouse, and they came out. They arrested my friend Mark for charged him with 7 counts of jury tampering. Why they didn't arrest me at that time, I don't know. But then I sent an email to the district attorney that said exactly this. What the fuck is wrong with you people? I handed out at least as many flyers as Mr. Iannicelli, and I demand equal justice under the law. You must also charge me with 7 felony counts of jury tampering. I'm so naive. I'm thinking a prosecutor's going to see this. They're going to look at this case and they'll be like, oh, no, this is classic First Amendment situation, and dismiss Mark Iannicelli's charges. I had no idea in the world that they would actually take me seriously and have me arrested and charged with 7 felony counts of jury tampering.
So what happened next? How did this get to the federal or Supreme Court?
So other activists, Janet Mattson, Eric Verlo, and Nasla McDonald, among others, I believe, filed for a federal injunction because they were so outraged at this that they too wanted to educate people coming into the courthouse. And so they filed for a federal injunction, and the federal court granted the injunction and told Denver to stop arresting jury nullificationers. Well, the city didn't stop, and they kept stealing our stuff. And so we moved in to the courthouse plaza, and we occupied the Denver courthouse plaza for 57 days and nights before they finally pushed us off of the plaza with endless arrests that ultimately, over a period of years, the city of Denver, and in particular a deputy, Jason Foose, were found in contempt of federal court. But we hit them really hard with that. There was a huge impact. We saw a substantial increase in the number of juries that would acquit the defendants. And we also saw a substantial increase in the number of criminal defense teams willing to take cases to jury trial, knowing that we were out there educating jurors. The final note on the jury nullification is that it went all the way to the Supreme Court. And the Supreme Court issued their findings. They agreed with the district court's dismissal of our case, and they said that they make it absolute that distributing literature about jury nullification in front of courthouses in Colorado is protected speech.
So the second piece of case law was set after Denver, Colorado police arrested you unlawfully because, if I understand correctly, you had a statue-like creation with the F word embedded with it. Can you describe that situation for us?
So back in June of 2014, I was just minding my own business, walking down the streets of Westminster with a giant middle finger sign that said, "Fuck cops." And they arrested me. But this was an interesting one because this is one where they escalated their tactic, and people called the police. People went to the police department to complain. And this was the first time that the police recognized that they had a First Amendment problem with arresting me for the sign. So they encouraged the citizens to file complaints in writing and sign the complaints. In one witness's case, they actually went to her home with the blank forms to have her sign it. And so they arrested me for walking down the street with that sign. So I won the criminal case on that. And then David Lane with Kilmer, Lane and Newman, and Andy McNulty, his one of his associate attorneys, they filed a lawsuit back in 2016. And this suit moved forward through the courts. There were lots of delays. There was delays on both sides. And then it came up finally for a summary judgment. The summary judgment was in our favor. The city appealed that. So it went to the 10th Circuit Court of Appeals. And the 10th Circuit Court of Appeals came down and said, disorderly conduct, disturbing the peace, the limiting clause that says tends to incite an immediate breach of the peace, that strictly limited liability to actual fighting words. So it wasn't a matter of you being offended. It wasn't a matter of it disturbed your sensibilities. It is a matter of you were compelled to an immediate reactionary act of violence to make it stop. Now, I've won 5 federal civil rights lawsuits. The most recent one was the Westminster case. This case has never come to trial, right? We filed it in 2016. Then it was finally going to come to trial last year, and my judge dropped dead of an aneurysm. So now it had to be put on another judge's docket, and it got delayed again and again and again. And then finally, with COVID, the courts have said, hey, civil trials are taking a back seat. We've got to do criminal trials first. We're backlogging them. There are time deadlines on the criminal trials. You should not expect to see a civil trial until probably January of 2022. So the city of Westminster, after years of fighting this case, finally said, we're all in. And I just won that lawsuit after 7 years of fighting. They paid out $97,500, of which, of course, my attorney gets his probably less than fair cut.
Now, I mentioned that you've suffered losses in court, too. What has been the downside or the personal cost to this activism? And is it really worth it?
The downside has been that I now have a fairly lengthy criminal record because you can't win them all. Not only can you not win them all because the system is certainly stacked against you, but you can't win them all because you don't always get it right yourself. So there have been mistakes along the way. Remember that when I started doing this, I knew nothing about what I was doing. And so I made a lot of mistakes, and so hopefully people can learn from my mistakes and not suffer some of the losses that I have. The losses I've spent over the last 7 years, I've spent about 2 of those years behind bars. And I am anticipating that I'll probably spend another 3 years behind bars.
Too few people have had the courage to challenge the government in qualified immunity, such as Philip Turner and Eric Brandt have. It takes a certain kind of courage to stand up to your oppressors. And unfortunately, in today's day and age, that trait is slipping away from modern people. We honestly need more people like Philip Turner and Eric Brandt in the world. People that are brave.
It's important to step back and understand the genesis of the central idea underlying the statutes at issue 14-1983. Section 1983 provides a federal cause of action for a person to seek monetary relief from state or local officials who, acting under the color of state law, violate that person's constitutional or other federal rights. Congress passed the measure as part of the Ku Klux Klan Act of 1871, 3 years after the 14th Amendment's ratification, and 6 years after the South laid down its guns and said, "Ali Ali and free, we're finished." It did so out of concern that, notwithstanding the 14th Amendment's guarantee of equal protection laws for all American state and local government officials, including police officers at the time, not only acquiesced in but participated and perpetrated racial violence and other forms of racial discrimination against black Americans. This conduct eventually continued under Jim Crow laws. It was less virulent, but just as present in other forms. By providing a cause of action, Congress intended for victims to receive some measure of justice for the violation of their federal rights by state and local government officers. And as the Constitutional Accountability Center noted in its written submission to the subcommittee, Congress also intended for private litigation to be means of deterring constitutional violations by imposing financial liability on the offenders. Sanctions, so to speak. The qualified immunity defense, as applied over the last several decades, subverts Congress's intent in passing Section 1983 by effectively making it impossible in all but a handful of cases for victims of constitutional or civil rights violations to obtain a remedy or even just have their day in court. This is so because courts have persistently narrowed the scope of the clearly established standards over the course of decades. In effect, in order to defeat a qualified immunity defense, a civil rights plaintiff would have to show that there was precedent existing at the time of the alleged civil rights violation that was precedent that was almost identical to the plaintiff's case, not only legally, but factually, through an eye of a needle. This can have terrible consequences from legal, policy, and moral perspectives. More importantly, victims are left with no remedy or even the chance to develop the facts in their cases in the face of dismissal of their lawsuits based on qualified immunity, a defense that can be raised at any stage of litigation. In addition, egregious misconduct that could amount to unconstitutional actions by police or other officials can go unpunished and undeterred in the future. This threatens to undermine the remedial and deterrent purposes of 1983. Also, by allowing courts to avoid merits decisions on whether particular challenged conduct is unconstitutional, allowing them instead to simply answer the question of whether the defendant's conduct violated clearly established law, the qualified immunity doctrine stymies the development of case law interpreting and defining the contours of constitutional law. This does a disservice to police officers, other government officials, and all other citizens. These consequences are particularly tragic when weighed against the minimal benefits of qualified immunity in the policing context. For example, other areas of substantive and procedural law already account for good faith conduct by officers acting under exigent circumstances, so the harm seems to outweigh the good when it comes to qualified immunity in police misconduct cases. In light of the foregoing, I hope we will hear thoughtful solutions to problems with the qualified immunity doctrine. Solutions could range from full elimination of qualified immunity in Section 1983 cases to a more targeted curtailment of the defense to other potential measures. Both last Congress and this Congress, I joined full committee chair Nadler, Representative Bass, and other colleagues in co-sponsoring the George Floyd Justice and Policing Act. It certainly seems like an oxymoron, doesn't it? George Floyd Justice and Policing Act, which among other things would have eliminated qualified immunity for law enforcement officers. Last Congress, I also introduced H.R. 1489, the Civil Rights Enhancement and Law Enforcement Accountability Act of 2021. This legislation would make the employers of any law enforcement officer vicariously liable under 1983 for the officer's violations of a person's rights while also preserving the individual officer's ability. To be clear, I do not intend this proposal to be an alternative to addressing qualified immunity, but rather to be a complement in doing so. Although it could be an alternative because to still have the ability of the government to, if they're liable for the damages, they will make sure that the officers are taught and reinforced to do the right thing and what the right thing is. I am a proponent and knowledgeable in government and society over the years of the police and law enforcement in enforcing and continuing to be a positive force and an underpinning of the rule of law, which is what makes our country so great. And society has to have rules of law to continue and to prosper and protect its citizens. We want to, as the president's budget will, fund the police. We don't want police to be used as piñatas in courts, but we do want police to do the right thing. And if they don't do the right thing, there needs to be a source of, a remedial source to remind them of the right thing and to make sure it's on their minds. Responding to superior work could do as well. I thank our distinguished panel of experts for being here, and I look forward to hearing their testimony, which promises to be a substantive and meaningful debate on a topic of great national importance. And I would now like to recognize the ranking member of the subcommittee, the gentleman from Louisiana, Mr. Johnson, who will save me from doing anything beyond calling recesses for his opening statement.
Thank you, Mr. Chairman. I think our witnesses for being here this morning. And I also want to take just a moment to honor the great men and women in law enforcement and recognize the essential role they play in keeping our country safe. You have an ally in me and my colleagues, certainly on this side of the aisle. At this hearing, we're going to discuss policing in America and whether the doctrine of qualified immunity should remain intact. For anybody who's not aware, there are some people who watch these proceedings at home. Qualified immunity is the doctrine that protects law enforcement officers from civil liability for honest mistakes they make while serving in one of the most high-pressure jobs in the world. The vast majority of police officers in this country are self-sacrificing public servants. They put their lives at risk every single day when they put on that badge. I know this from my own experience. I grew up at the Fire and Police Training Academy in my hometown of Shreveport, Louisiana, where my dad was a training officer and assistant chief before he was critically injured and permanently disabled in the line of duty. If we're going to ask our officers to potentially make the ultimate sacrifice for the safety of others, we have to provide them with legal protections that qualified immunity affords. Period, full stop. However, despite the sacrificial service and bravery of law enforcement, there are some Democrats in Congress who continue to push the false and outrageous narrative that police are actually somehow to be regarded as the enemy. We all saw this over the last couple of years, and as we all know, there are some on the progressive left, some elected members of Congress who've gone as far as to call for the full-scale abolition of police, if you can imagine that. It's insanity. My Republican colleagues and I are here to tell you that they are wrong, stating the obvious. We need police officers, and we must maintain law and order.
The problem of qualified immunity goes well beyond the police. As a former civil rights litigator, I actually rarely sued the police. I sued lots of other people, and they invoked qualified immunity. And so we should be addressing this problem writ large. Many examples in the public mind right now involve the police, and we shouldn't exempt them from any change in qualified immunity. But we have had egregious situations in North Carolina with the Department of Social Services. We've seen egregious situations and treatment of women. We've seen egregious situations with racial discrimination and discrimination against immigrants. And all of those issues should be on the table today. As we know, the doctrine of qualified immunity protects state and local officials, not just the police, where they can only be held liable for violating somebody's rights if a court has previously ruled that the actions are unconstitutional. The actions, and therein lies the problem. If no decision exists, the official can be immune from liability even if they intentionally violate the Constitution. Qualified immunity acts like a time warp. In its current form, the doctrine allows conduct to be judged by completely outdated standards and parts of our history that we are trying to rectify. It doesn't let us rectify history. Public officials should not be allowed to avoid the consequences for egregious actions by hiding behind judicial opinions that previously found conduct acceptable. The actions of law enforcement and other public officials must be judged under evolving standards of what constitutes constitutional conduct, not decades or centuries old endorsing of unconscionable practices. My first question is for Mr. Schweikert. In your written testimony, you cite several cases in which qualified immunity was granted because the cases differed just slightly from clearly established precedent. In the interest of time, I'm not going to go through a couple of them, but my question is, how has the clearly established law test stunted the development of constitutional law?
Thank you very much for the question. It has stunted the development of constitutional law because the Supreme Court has held, as Mr. Mangle has previously discussed, that courts are allowed to dismiss a case by saying, well, we're not even going to decide whether this was constitutional or not. We're just saying it's not clearly established, so qualified immunity case dismissed, which means the law then does not become clearly established going forward. And so this is why Judge Don Willett has called qualified immunity a catch-22. And it means that, in fact, the exact same misconduct could be committed the very next day, and again and again and again, it could still be excused based on qualified immunity because courts refuse to decide the constitutional question, especially in the most difficult cases where clarification of the law is most needed.
Thank you very much. And Mr. Ago, we got a great example from Mr. Roy earlier of local officials who violated constitutional rights but were granted qualified immunity not in the law enforcement context. Could you share with us other examples outside of the law enforcement context?
Thank you, Congresswoman Ross. The Lawyers Committee is concerned about law enforcement because of the devastating and differential impact of police abuse and misconduct against communities of color. That said, there are substantial numbers of examples outside of the law enforcement context where, for example, public school teachers abuse their power. Situations like what you mentioned, Congresswoman Ross, social workers abuse their power and violate the constitutional rights of the people that they're supposed to be serving. So that there are lots of examples outside of law enforcement. The Lawyers Committee's concern is law enforcement, though.
And to our distinguished judge with my last 16 minutes, 16 seconds, I'm sorry. I wish I had 16 minutes. Would your solution deal with this broad problem much more effectively?
Yes, the answer is yes. I think it would make it an effective remedy, and I think it would make it a modification that has some chances of being enacted. And from the controversy I've heard today, I despair that as what happened 30 years ago when I testified to you, nothing happened. So I think you ought to consider municipal liability, employer liability generally, in order to get something done about this problem.
The doctrine of qualified immunity must be eliminated through legislation. And at the same time, Congress also must pass a new law giving people the right to sue federal officials for violation of their civil and constitutional rights. Our civil liberties are dependent on it.
Now is the time to make your voices heard to the people with the power to do something about this atrocity of the law now. We need to get qualified immunity eliminated countrywide. One of the most effective ways to do that right now is to make your voice heard with your local Congress representative. The best way to do that in our modern age is use the technology at hand, more specifically Google. Use Google search to find out who your specific Congress representative is. You can simply type, "Who is my Congress representative?" followed by your state or zip code. Then, Google your representative's name along with the term contact information, or visit their local website or office where you are likely to find contact details. Most representatives provide email addresses, phone numbers, and sometimes even online contact forms. You'll need to draft a concise and clear message expressing your concerns about qualified immunity. Be specific about the issues and explain why it matters to you and your community. Use respectful and professional language. You want your message heard at the end of the day. If a phone number is provided, you should call the representative's office. Be prepared with a brief script summarizing your concerns about qualified immunity, as calls are often short. Some representatives are even active on social media platforms. You can tweet or message them on platforms like Twitter or Facebook expressing your concerns. Ensure your message is concise due to character limits. Now, if you don't receive a response within a reasonable time, consider following up. Persistence can be key to getting your concern noticed. We want our voices heard. We want to abolish qualified immunity. Let it be known.
So you would abuse your authority if I exercise my right? Whatever. I don't personally care what you sentence me to. I'm appealing everything today, so it's going to freeze whatever you sentence me to, and we're just going to kick it to a higher court. Because clearly this one is corrupt.
They turning our communities to hot blocks. Yeah, they got Glocks, handcuffs, and badges. They swearing that they hot shots. They want to lock us and throw away the stopwatch. You know, direct deal, show you how to cop. Watch, cop, watch. Record them when a cop stops. And ignore the pig chatter when a cop talks. You don't need a top-notch camera, just a cop watch. You gotta know your rights or you lose them. So we cop, watch.